We're going to start, but then you can just jump out. Where is my... So good morning. Today's subcommittee on capital markets and government-sponsored enterprises is called to order. Today's hearing is entitled Oversight of the SEC's Enforcement Division of Enforcement. And I thank our witness for being here today. And before I begin today's proceedings, I'll just take a moment of personal privilege. You know, when you're on the floor and you come to the conclusion of some major piece of legislation, whether it's the budget or the defense bill or something else, at the very end of that whole process, what always happens is that the chairmen from both sides get onto the floor and they give thanks to all the people who made the culmination of that project possible. So I'm going to do that before we start this hearing today. By thanking a member of my staff who's been with me for a very long time to making not just this culmination of this hearing, but the culmination of the last 12 years, my entire tenure here in Congress, possible and as successful as it has been. It's through this gentleman's dedication, his interest, his keen insight into the issues, and his general interest in in all the topics that we cover in capital markets and in financial services generally and specifically, whether they are issues that are fun issues or issues that are totally boring to other people. This gentleman always was there to look at them and make them interesting and make them understandable, not only to me, but to the rest of my office, and hopefully, I think as well, to our committee as well. And I very much appreciate all that he has done. As I said, it has been 12 years now, which is, in this Washington's time, a lifetime. Many people come in every 2 or 3 years, come and go, but 12 years is a lifetime. And during that lifetime, I've seen this gentleman go from an unmarried guy who spent a lot of his time down on the ball fields playing sports and downtown doing other things, which I won't go into, to a gentleman who is now married with a couple of kids and spends more of his, or all of his time, not all, some, but all of his time when he's not with me, back at home with his beautiful wife and children, taking care of them, but still able to, at the end of the day, make me look good and make me look as if I actually know all this stuff that I'm talking about here today. So I would like to just take this moment again to thank Chris Russell for all that work and all that dedication and just being there for us, for myself, and for our committee, and for my family as well. So thank you so very much. Thank you, Chris. Our loss is, I guess, as I say, downtown's gain. I have a feeling that we will still see him up here on a regular basis, right? Yes, sir. Good, because I still have lots and lots more questions to ask as we go along. So thank you very, very much, Chris. I appreciate it. So with that said, it brings the conclusion of today's hearing. Because he did not prepare any other opening statements or questions for me since he's leaving now, so I have nothing else to say. No.
And we know that's not true.
What, that I have nothing else to say? Thanks. Yeah. So we'll turn now back to the matter at hand. Again, we thank the witness for being here, and today's hearing on the Enforcement Division. We will be begin with opening statements, and I'll yield myself such time. I don't know where clocks are around here. I'll yield myself such time as I may consume, and I'm not sure who on the ranking side will be speaking. So today's hearing, as I say, will examine the policies and procedures of the SEC Division of Enforcement. Now, while the SEC is first and foremost a disclosure agency, I support a strong enforcement function at the SEC. This enforcement function, however, must be used in an even-handed, non-political manner that preserves the due process rights of issuers, regulated entities, and their employees. Recently, I heard an interesting distinction between blue-collar and white-collar crime. The saying goes, with blue-collar crime, you know that there's been a crime committed, you just have to figure out who did it. With white-collar crime, you know who did the crime, you just have to figure out if it actually was a crime. This saying implies that there's a degree of nuance required by regulators and enforcement officials when making decisions whether and how to bring civil actions against potential violators. One area where there is most needed is the Commission's increased use of administrative proceedings. While bringing more cases through the administrative proceedings can lead to lower costs for the agency and increases in efficiency, it's important to realize that those who benefit comes with a cost. The cost is less due process protections for defendants. Because the SEC administrative proceedings use the SEC's procedural rules, respondents are forced to operate on a condensed time frame and do not have the benefit of many of the fundamental due process protections provided under the Federal Civil Procedures Act and the Federal Rules of Evidence, such as full discovery rights and the right to jury trial and the exclusion of hearsay evidence. Moreover, initial appeals of administrative law judge, ALJ, rulings must be made to the full Commission and the ALJ's employer rather than Federal District Court. While the Commission's decision may be appealed to the D.C. Circuit Court of Appeals, the SEC's interpretation of the security laws generally will be given significant deference. Appealing an administrative decision is a time-consuming and expensive proposition. As a former SEC division official put it, quote, "The entire process ordinarily takes years, during which many SEC targets are bankrupt by legal costs and their ability to find work with reputable companies. Only after SEC commissioners decide all appeals can be the accused finally seek relief from the Federal court. But appeals rarely succeed because the law requires the court to defer to the agency's judgment, especially on disputed facts," unquote. So this, coupled with the SEC's 100%, that's a pretty good success rate, 100% success rate from the year 2014, illustrates a very troubling pattern of the SEC's attempting to stack the rules and process in a way that the outcome of the case is, well, predetermined. This is not appropriate in a country that values appropriate due process for its citizens. Due process is a fair process, and fair process is fair play. Other issues that I'm equally concerned about and hopeful to address today are the inappropriate delegation of authority to SEC staff to issue subpoenas and compel testimony and documents, the comments in SEC press releases by enforcement officials that presume guilt instead of innocence of recently charged market participants, the lack of cases against specific individuals compared to cases against the corporations, and the lack of any structure or legal guidance around determining the sought-after penalties in settlements and cases, and finally, the backdoor changes to Commission policies included in the very enforcement actions at the end of the game. So let me reiterate. I strongly support the proper and stringent enforcing of our nation's security laws. However, the enforcement of those laws, like any other, should be done in an even-handed manner, removed from politics, with appropriate due process protections for the defendants. The current SEC enforcement policies come into question as whether they meet the standards and need to be improved. The SEC should be less concerned about the press release it sends out and the headlines it receives, and really more concerned about having a clear and consistent approach to enforcing the laws. With that, I yield and look to Mr. Lynch for such time as you may consume.
Thank you, Mr. Chairman, and I too want to congratulate Chris Russell on his 12 years. That's a long time to be serving here, and you have certainly helped the committee out greatly, and we appreciate your service as well, and we wish you very good luck in your next endeavor. I do want to just comment just briefly on subpoena power and about the SEC extending subpoena power to its employees. I just want to remind my friends, and you are my friends on the other side of the aisle, that this Congress, under the Republican House, has expanded subpoena power among, I mean, the gal that runs the elevator has subpoena power in this Congress. We have expanded the subpoena power for for many, many chairmen that never had it before. So I am much more comfortable with the SEC having subpoena power and doing so in a deliberate and responsible manner than I am having it so widely dispersed here in the Congress. I do, Mr. Director Cerezny, I want to just mention one area where I think we can do much better at the SEC with the limited resources that you have, and that's the revolving door situation with SEC employees. We've had situations where, I mean, I'm completely comfortable with folks at the SEC. They work, they learn the system, they understand, they have value in the knowledge that they gain because of their service at the SEC, and then at some point they make a lateral move. They go to the industry that can pay them much more money, and they have earned it. They have earned it. The same thing with our staff here. They toil here for a while. They do their sentence, and then hopefully they gain enough acumen and ability that someone seeks to hire them. This is a different situation that I'm addressing here. That is when SEC employees are involved in an enforcement action against a bank or a financial service company or any entity, and then while that enforcement action is ongoing, they leave and they go to work for the other side, for that company that has an enforcement or has a waiver pending. That cannot happen. That cannot happen. You can't have somebody working at the SEC prosecuting an enforcement case, and then all of a sudden the next week they go out and they're working for the company that they were just prosecuting last week. That cannot happen. So it does happen. It does happen. And so I recently introduced the SEC Revolving Door Restriction Act of 2015. This legislation will reduce the conflicts of interest beyond the current ethics rules. Specifically, this bill amends the Security Exchange Act of 1934 to prevent former employees of the SEC from seeking employment with companies against which they have participated in enforcement actions in the preceding 18 months. Just gives them a little cooling off period. You can't go to work for somebody you just prosecuted or waived an enforcement action against within 18 months. That would hurt the credibility of the SEC and hurt the integrity of the process. If that employee wants to go to work for that person, we leave an option here. If they're low level, not very much involved, they can go and get an ethics opinion that says that going to work for that company does not present the appearance of impropriety or compromise the standing of the SEC or put any party in that enforcement action at a disadvantage or give them an advantage. I believe that these added measures will improve confidence in the agency's ability to investigate suspected wrongdoing and continue the SEC's recent efforts to strengthen the agency's enforcement actions. This SEC Revolving Door Restriction Act of 2015 is supported by the Project on Government Oversight, POGO, a nonpartisan independent watchdog, and POGO has detailed the dangers of the revolving door, blurring the lines between the SEC and the interests that it regulates in a 2013 report. Dangerous liaisons, revolving door at the SEC creates a risk of regulatory capture. So they lay out the cases, the individual cases where this has happened, very powerful, and I want to give credit to POGO, the Project on Government Oversight, for the work that they've done on this. They really were the catalyst for my legislation. The report highlights that some SEC alumni routinely help corporations try to influence the SEC rulemaking. They also help them counter the agency's investigations of suspected wrongdoing, and they often try to soften the blow that the SEC might otherwise deliver in enforcement actions. They also block shareholder proposals, and they also, in times, win exemptions from Federal law. So, as I said, if we're going to maintain the SEC's integrity and the integrity of this process, that cannot happen. I thank you, Mr. Chairman, and I yield back the balance of my time.
Thanks. And the gentleman yields back. Gentlelady from New York is recognized for such time. as she may.
Thank you, and my apologies. The meetings get earlier and earlier. I've already been from a meeting this morning. Thank you, Mr. Chairman, for holding this hearing, and we welcome you. The SEC's Division of Enforcement has a very important job. It is the sharp end of the spear, so to speak, for the SEC. It investigates and prosecutes individuals and companies for violations of securities laws. And it's fair to say that the Enforcement Division makes all of the other divisions at the SEC matter. After all, there's no point in writing rules if they're not enforced. So the Enforcement Division is facing significant challenges. For example, despite a modest increase in your budget, the Enforcement Division is still vastly outspent by the white-collar defense bar. And the Second Circuit's recent Newman decision poses a real threat to the Enforcement Division's ability to police the markets for insider trading. Nevertheless, the Enforcement Division has made significant progress under the leadership of Chair White and Mr. Cerensky, and the SEC has adopted a broken windows approach to enforcement, in which there is no violation too small to pursue, and the goal is to make market participants feel like the SEC is everywhere. While it's still too early to judge the success of this enforcement strategy, I believe we should start thinking about how we should measure the success of an enforcement strategy whose main goal is deterrence. I look forward to the hearing today. Thank you for being here.
Thanks for those. And so now we turn to Mr. Strazny. Thank you very much again for being with us, Director of Division of Enforcement over at the SEC. You are recognized for 5 minutes.
Thank you, Chairman Garrett, Ranking Member Maloney, and other members of the committee. Good morning, and thank you for the opportunity to be here today. A strong enforcement program is at the heart of the Commission's efforts to ensure investor trust and confidence in the nation's securities markets. And the Commission and the Division of Enforcement are committed to the swift, vigorous, and fair pursuit of those who have broken the securities laws. The Division investigates potential violations of the federal securities laws, recommends enforcement action to the Commission, and litigates the enforcement actions to completion. Enforcement staff include investigators, accountants, industry experts, trial attorneys, and other employees in Washington, D.C. and the regional offices. The Division works closely with the other divisions and offices of the SEC and regularly coordinates investigations with other regulators and law enforcement agencies, including the criminal authorities. In FY 2014, the Commission brought the highest number of enforcement actions to date, 755, and obtained monetary remedies at our highest level, totaling over $4.16 billion. More importantly, though, these enforcement actions address significant issues, span the entire spectrum of the securities industry, and included numerous first-of-their-kind actions. We punished securities law violators, returned funds to injured investors, and sent important messages of deterrence. The Division is focused on a number of important areas that are central to protecting investors in the markets. Comprehensive and accurate financial reporting is critical to ensuring that investors have access to reliable information and can make informed investment decisions. Because false or misleading financial information erodes the integrity of the markets, we have intensified our focus on this area and recently have seen a significant increase in financial reporting and auditing investigations and filed actions. Investment advisors and the funds they manage also remain a focus of the Division, and we regularly investigate and bring actions against investment advisors for conflict of interest, misrepresentations regarding performance or investment strategies, breaches of their duties to their clients, and other fraudulent conduct. The proliferation of sophisticated trading technologies, such as algorithmic and automated trading, has transformed the securities markets. These changes in the markets present significant potential risks to investors. The Division has recently filed a number of actions against market participants that pose a risk to the markets by failing to operate within the rules and has ongoing investigations into other potential violations of law related to equity market structure. In the area of municipal securities, which are an important investment vehicle for retail investors, enforcement is focused on investigating misrepresentations in connection with bond offerings, failures by underwriters to meet their obligations, undisclosed conflicts of interest, and pay-to-play violations. Policing insider trading has long been central to the Commission's mission of ensuring confidence in the markets, and the Division has sent a strong deterrent message to would-be violators by charging more than 590 defendants in civil insider trading cases over the last 5 years. Pursuing violations of the Foreign Corrupt Practices Act remains a critical part of our enforcement efforts, and last fiscal year, the Commission obtained orders for over $380 million in disgorgement and penalties in FCPA cases. A common thread throughout these priority areas is the emphasis on the importance of gatekeepers to our financial system: attorneys, accountants, fund directors, board members, transfer agents, broker-dealers, and other industry professionals who play a vital role in the functioning of the securities industry. When gatekeepers fail to live up to their responsibilities, the Commission will hold them accountable. The Commission's ability to successfully litigate cases is critical to the mission of protecting investors. When the Division goes to trial, we have had a strong record of success, despite the difficulty and complexity of our cases. The Division strives to be proactive and efficient as it investigates violations of the securities laws, and we continually work to assess and refine our approach. Some recent efforts include requiring admissions of misconduct in certain cases where heightened accountability and acceptance of responsibility by a defendant are appropriate and in the public interest, leveraging the knowledge of various experts hired to give insights into the market and industry practices in its investigations and litigation, and using large-scale data analysis to assist in the identification of misconduct and conduct more sophisticated investigations. Going forward, we will continue to take the steps necessary to permit the Division to more effectively and efficiently protect investors and the markets. Thank you again for inviting me to discuss the Division of Enforcement. I am happy to answer any questions.
Great. Thank you very much. So I'll begin with questioning. Recognize myself 5 minutes. So like 2 or 3 major areas. One is the administrative proceedings, which I touched on in my statements. So last year you were quoted as saying, there have been a number of cases in recent months where the SEC has threatened administrative proceedings. It was something that we told the other side we were going to do, and then they settled, end quote. So based upon your statement, do you believe it's appropriate to use statements not like that, but I'll say the threat, if you will, of that you're going to use an administrative proceeding against the defendant in the manner basically as a threat, knowing that what the outcome was going to be if you go through an administrative proceeding hearing?
So administrative proceedings is a procedure that's available to us, and we try to use it when it's appropriate to protect investors. And we look at a whole bunch of factors to determine whether an administrative proceeding is appropriate. We have used it for years against regulated entities and individuals, and the only change, frankly, in the recent past that expanded the use of APs was Dodd-Frank, which gave us the authority to obtain penalties against non-registered individuals.
So, why don't you just stress that point again? What is that change in Dodd-Frank?
Dodd-Frank gave us the authority to obtain penalties against non-registered individuals and entities in administrative proceedings, whereas before we could only obtain those penalties in district court actions. And so that's the only expansion of the use of...
But that's a significant expansion, wouldn't you say?
It is significant, but it allows us now to obtain...
And so has there been a significant uptick then in the number of ALJ cases versus trial cases?
There has been, but most of those cases...
Can you give a percentage or increase or anything like that?
Well, I should just say that most of those cases are settled cases. So most of those cases are cases in which the other side is agreeing to a settlement with us. And so the uptick, I think, if you look at it, is probably more pronounced because we are settling more cases.
Well, what's the, I threw out a number in my opening statement. What is the correct number of your success rate, if you will, when you go through ALJ? I said 100%, but what is the number?
That was through last year. And actually, yesterday, we actually lost an administrative proceeding against an individual, and an ALJ ruled against us in connection with the Penson matter.
Yeah.
And that's been true in prior years. Last year, we did have an unanimous record. I should say that that doesn't necessarily reflect that we won every claim. It doesn't necessarily reflect we got the remedies we were seeking. And in many cases, the ALJs are pretty concerning.
The intention of, or the way I was toning my comments was that you have a fairly high success rate, 100% or akin to that, or in that area. So what are the rules? What are the procedures? What are the guidelines that you use in order to make that determination that you're going to go that way and make that, I'll use the word threat again, against the defendant in the case?
So we use a number of facts and circumstances. First, there are certain proceedings we can only bring as administrative proceedings. So that includes failures to supervise and causing violations. Second, in cases where we need quick relief, where we want to get a bar very quickly or we want to get investors relief quickly, administrative proceedings can be much more quick than district court actions. District court actions will often take years to get a resolution in. APs, we can get a decision within 300 days of the institution of the action. So that's important. And another important point is where we have technical rules or where we have complicated rules, like some of our rules are very complicated, we have sophisticated fact finders who are the ALJs, whereas a jury, it would be much more difficult for them to grasp those very, very complicated issues. So those are some of the issues, but there are many reasons to use district court, including where we can get summary judgment. We can't usually get summary judgment in an AP, including where we need discovery about privilege issues, including where we need expedited relief and emergency relief.
So you just laid them out here. Is that all in written format for your staff to follow?
We do have some guidance internally for our staff.
Yeah, can you supply that to us so we can see what those guidelines are and understand them in better detail that I can get in 4 minutes here?
Let me consult, but we'll come back to your staff on that issue, yes.
And, this is not just me raising this case, this issue. Recently, District Judge Rakoff stated that bringing more cases before ALJ, quote, hinders the balanced development of the securities laws. The results would be that law in such cases would effectively be made not by neutral federal courts, but by SEC administrative judges. So even independent bodies, judges are calling into the question what is occurring right now at the SEC.
Okay.
So do you agree with what he's saying?
I have great respect for Judge Rakoff. I disagree on this fact, which is I think that what you get when you have an AP is you get the Commission weighing in on the securities laws, the Commission with the expertise they have, and then you have review by the Court of Appeals. And
but aren't they developing law then by doing that, administrative law judges, when they make some of these decisions and making new federal law? And they're not Article III judges, right?
The Commission reviews those decisions, and the Commission, I think, is obviously appointed by the President and confirmed by the Senate, and they have expertise in the securities laws. And then, after that expertise is exercised, the Court of Appeals has the ability to review that. And so I do not think that you are taking away from the courts the ability to shape the law.
Well, you laid out somewhat of the procedures that you use in order to do this. Is it possible that you will bring these cases, both similar situated cases, both in one day in a ALJ case and next day in a Article III judge case?
Well, last year, if you look at our statistics last year, we brought 57% of the cases that were litigated in district court and 43% as an AP.
So does that mean that you get different results because of that, interpretations of the law? And then I'll yield back.
Obviously, you can never tell whether a result would be different in one forum or the other. But our overriding goal here is investor protection, which is our mission. And we use the forum that we think is appropriate for the goals of investor protection.
Yeah. I'll yield back at this point. But since we know that many people, maybe we'll get a second round of this. The ranking member is now recognized for 5 minutes.
Well, thank you, Mr. Chairman. And following up on your line of questioning, any of us who's been in court knows it is incredibly time-consuming and incredibly expensive. And as Mr. Serezny noted, you can be in court for years without any solution, and that doesn't help. It doesn't help investors, and it certainly doesn't help business having a decision. So I supported the expansion that was in Dodd-Frank that expanded the SEC's authority to try cases in an administrative forum where they can be made by administrative law judges in order to speed up the system. And some critics have said that the SEC's administrative proceedings amount to what would be called a, quote, home court advantage, end quote. And some have even claimed that it deprives defendants of their due process. So I'd like to ask you to speak to those issues. Do you think the SEC gets an unfair, quote, home court advantage when they try cases in front of an administrative law judge?
I do not. Administrative proceedings have additional protections that actually defendants don't necessarily have in district court, including our obligation to produce Brady material, exculpatory material to the defense, Janks Act material, which is prior witness statements. We turn over the investigative files 7 days, usually 7 days within filing our cases, which we do not do in district court proceedings. There also are exhibit lists and witness lists provided, typically in administrative proceedings, extensive such. And so there are lots of protections. I think the one major difference, defendants also get subpoena if they show good cause, and they can subpoena documents. The one major difference is obviously the lack of depositions. And I think the fact is, if you look at our criminal cases, criminal authorities don't give deposition authority, and that clearly is not a due process violation. So I think it can't be a due process violation to deprive defendants of depositions in this context.
Well, that's the second criticism that I've heard, that defendants are still not receiving their full due process. And can they appeal the administrative law judge's decisions?
Yes, they can appeal to the full commission. The commission hears the appeal in the first instance, and then they can also appeal after that the commission's decision to the Court of Appeals.
Could you just outline briefly what are the due process protections? You were talking in general, but can you just hit them like bullet points? What are the due process protections?
We have obligations to turn over Brady materials, which is exculpatory evidence, JANG-SAC materials, which are prior witness statements. We turn over our entire investigative file, including any prior testimony by any witness within 7 days, typically within 7 days of our institution of the proceeding. We provide exhibit lists and witness lists that lay out in great detail what our case is going to look like. As I said, defendants also have the ability to obtain subpoenas of documents for good cause. And so I think, the defendants have an extensive record which allows them to see exactly what we are charging.
Okay, it sounds like a good process to me. Are you getting criticism from investors or institutions about the administrative law judge procedures?
I have not heard criticisms from investors about the administrative law judge's procedures. Obviously there has been some public dialogue about it.
Okay, I'd also like to ask you about the fact that when people talk about the enforcement division and whether or not it's been successful, they cite statistics on how many cases the SEC has brought and how much money they've collected in fines. And the bigger the numbers, the, quote, more successful the enforcement division is supposed to have been. And this has always seemed extremely strange to me. If the SEC is bringing huge number of security fraud cases, for example, doesn't that suggest that there is more securities fraud in the markets? And how is that a good thing? And for me, this just highlights how foolish it is to judge the enforcement division based solely on statistics about the numbers of statistics and the numbers of fines and the number of cases. For example, how do you quantify the number of violations that did not occur because they were successfully deterred by the enforcement division? So my question is, should we be looking beyond simple statistics and instead looking at a broader range of factors to judge the enforcement division? And even if those factors can't be easily quantified. Could you comment? My time is up.
I agree that numbers are easy to come up with, and therefore those are often cited, but I agree with you that that is not the major touchstone of the success of our enforcement division. As I always say, the numbers are not the most important aspect of judging how well we are doing. From my perspective, it's about how the quality of our cases. Are we covering the entire security spectrum? Are we bringing cases that have an impact on investors and also deterring and punishing misconduct more broadly? And so we've tried, and it's not easy as you suggest, to look at cases more qualitatively and to assign sort of measures qualitatively to the cases. And so we're trying to emphasize that. We've talked about first-of-their-kind actions where we're bringing cases in areas we haven't brought before. I think that's important as well. So there's no question that numbers are not the end-all and be-all in terms of measuring our success.
Thank you very much.
Mr. Hurt is recognized.
Thank you, Mr. Chairman. I know the gentlelady from Missouri, Ms. Wagner, has some things she's got to do, so I was going to yield my time to her.
I thank the gentleman very much for his courtesy, and welcome. Good morning, Director Serezny. And thanks you for joining us today to discuss some of these enforcement issues with the SEC. Earlier this year, a White House memo dated on January 13th from Council of Economic Advisors Jason Furman and Betsy Stevenson was leaked that outlined the rationale for a new rulemaking from the Department of Labor to deal with conflicts of interest in the retirement advice market. Are you, Director, familiar with this memo?
I am not. The Enforcement Division obviously enforces the rules. We're not really involved in policy decisions about what...
Are you aware of the memo, sir?
I am not. I am not.
SEC Commissioner Dan Gallagher recently referred to it and as a, quote, thinly veiled propaganda designed to generate support for a wildly unpopular rulemaking. Director, I'm worried about the effects that such a rule would have on low and middle income Americans seeking financial advice for their retirement. And I'd like to get your perspective on some of the claims regarding this area.
In the Enforcement Division, we're in charge of enforcing the rules and the laws as they exist right now. And I think what you're referring to is a policy question as to what the law should be in the future. Should there be a different fiduciary standard? Should that fiduciary standard apply to broker-dealers and the like? And that's a policy question that really is handled by other divisions at the SEC and not one in which I'm involved.
Well, let me proceed here and say the memo stated that, quote, consumer protections for investment advice in the retail and small plan markets are inadequate, and that the current regulatory environment creates perverse incentives. Unfortunately, the memo does not analyze regulatory oversight or the protections investors currently receive from the SEC or FINRA. In fact, the memo doesn't even mention the SEC at all. Isn't it true that there are rules that require clear disclosure to investors about payments and fees, including, sir, incentive fees, and rules which prohibit the use of manipulation, deceptive or fraudulent practices?
There certainly are statutes and rules on the books that preclude fraudulent activity, and then we certainly vigorously enforce those. Vigorously enforce those.
Could you please help us fill in the blanks left on how the SEC currently regulates and enforces conflicts of interest and issues of quote, perverse incentives in the investment advice market?
Well, there is the law now does have a different standard for investment advisors than it does for broker-dealers. The broker-dealers are obviously governed by the anti-fraud provisions, and investment advisors have a fiduciary duty to their clients. So there is a difference in some of the standards that apply.
There is a difference in the standards. Does the SEC ever bring cases against investment advisors for violations regarding their fiduciary duty?
Yes, we do.
So there are still issues of investor protection even with a fiduciary duty at times.
Yes, but there are different standards that govern investment advisors, and fiduciary standard does have a different nature to it than the protections that apply to.
There were also claims, sir, that the current regulatory environment incentivizes advisors to recommend excessive churning of retirement assets. Doesn't the SEC have rules that expressly prohibit brokers from churning client accounts?
The anti-fraud laws do prohibit churning, and that's governed by a test that looks at things like turnover ratios and the like.
From an enforcement perspective, how do you handle these cases?
Well, we look for churning, and we try to, if we see indications of churning, we look to try to prove it by looking at things like the turnover ratio and the like.
What further ways can the SEC mitigate potential risks associated with conflicts as a deterrent through enforcement, sir?
Well, as I said, we in enforcement enforce the statutes and rules that are on the books now, and so we do that vigorously. Whether there should be a different standard or not is, again, not something that's within our purview.
If the Department of Labor potentially steps into this space that you have decades of experience in regulating, could that make your job through enforcement perhaps more difficult, sir?
I don't know. I'd have to sort of know more about what it is that the Department of Labor is going to do. I will say that we enforce the law as we see it. Whenever we see a violation, we will bring an action.
Thank you. I appreciate it, and I yield back my time and thank the gentleman for his courtesy.
And I thank you both. Mr. Lynch.
Thank you, Mr. Chairman. Director, I wanted to talk to you about WIXI waivers. As you know, Congress and the SEC has the ability to withdraw WIXI, well-known seasoned investor status, to a company if they are found to have, in particular, violated securities law and anti-fraud provisions. So I've sort of made a hobby out of tracking how many folks actually have their their well-known seasoned investor status withdrawn as a result of prosecution. And it's far more common for waivers to occur than it is to actually see prosecution. And, it just, we don't have a lot of success, I think, in especially looking at the financial crisis. Not a lot of people were prosecuted, at least high-level folks. Very little was done to hold people accountable. But this is a case where I think just last year the SEC granted 80 specific waivers when they could have penalized these companies for wrongdoing. One particular case that I found troubling was against Credit Suisse, and they actually pled guilty to criminal violation, and yet when the SEC was asked whether they would withdraw their well-known seasoned investor status, this is someone whose employees were guilty of criminal activity, we still didn't withdraw their status. So I'm just curious, where is that line? How do we review this? Because it looks like it is much more likely that you'll get a waiver from a penalty established by Congress than you might ever be prosecuted or be subject to this withdrawal of benefits. And of course, I should add that the well-known seasoned investor status allows them to use shelf registration. So that's a real benefit to these companies, and it seems to be a good leverage point that we could use to require them to refrain from violating the anti-fraud provisions or other securities laws that we've established. And I'm just curious, why don't we use that tool?
So enforcement is generally not involved in waiver recommendations or decisions. Those are typically handled by other divisions at the SEC. For example, the WICSE waivers are handled by the Division of Corporation Finance. My understanding is that waiver requests are carefully evaluated by the Commission staff and by the Commission based on the facts and circumstances of the case under applicable legal standards. It's important to recognize that WICSE disqualifications are not enforcement remedies. We have remedies that are available to us to punish misconduct and deter misconduct. For example, we have disgorgement, we have penalties, we have bars, we have undertakings, lots of different remedies available to us. But the disqualification and waiver question is a separate question. As Chair White indicated in a speech a couple of weeks ago, that's a separate question about whether it is appropriate for that particular issuer to function in this particular business activity going forward, and whether the conduct that is involved in the enforcement action suggests that they cannot do that responsibly.
So
that's a different
Credit Suisse, you were involved in that prosecution? The criminal prosecution?
I was not involved. We were not. We brought a separate case against Credit Suisse that was separate from the criminal case regarding unregistered broker-dealer conduct. I
wonder if the prosecuting authority actually recommended that WICSE status be withdrawn, or would that be overreaching on their part?
I'm not, again, without talking about any particular case, which I don't know that would be appropriate for me to do, I'm not aware of criminal authorities kind of expressing a view on a WICSE waiver decision.
I'm just curious, what is going on? So you have 80 waivers. I'm just wondering, do you know if we're using the threat of withdrawing that classification, WICSE classification, as a bargaining chip sort of in negotiations?
That's exactly why the Enforcement Division is generally not involved in the question about whether, because we do not want it to be a bargaining chip in our enforcement actions.
Okay. Thank you. I yield back. Thank you, sir.
Thank you. The gentleman yields back. We were looking for Randy. No. Mr. Fincher's not here. Wagner, Pollockman's not here. Phil, Heisinger. Mr. Heisinger? Sure.
I'm up? All right.
Yeah.
All right. Well, thank you. Sorry, I have to get back, gather my notes. I was being distracted by my Wisconsinite. He was bragging about how Wisconsin was going to win the tournament. So I don't know. I got to.
Bill agrees Wisconsin is going to win.
All right. You're reclaiming my time.
I'm not going to offer my predictions.
Yes. All right. All right. I am getting to the penalties phase, and let's get back to business here. When the former SEC Chairman Shapiro announced her intention to return the power to staff to determine penalties, it's my understanding she received a standing ovation. Now, at least that's what was reported. And I'd like to hear your thoughts on, should power to decide penalties really reside with staff, or should it reside with the 5 commissioners appointed by the President and confirmed by the Senate? And you have to understand, I'm a former staffer myself. I understand the importance and the power of staff, but at the end of the day, doesn't that seem like it should be political appointees and confirmed presidential appointees that determine that?
Every recommendation that we make, including about penalties, gets approved by the Commission. So at the end of the day, every penalty decision is approved by the Commission. We recommend to the Commission what the penalty should be, but it's up to the Commission to approve that.
But the staff determines the level, and then the recommend. How often is that overturned by the Commission?
I would say in the vast majority of cases, the Commission accepts our recommendation. That's true of penalties and other things. In the vast majority of cases, our recommendation is accepted. Occasionally there is an issue, but every penalty recommendation gets approved by the Commission ultimately. All
right. And talking a little bit about company versus individual penalties on that, I have a quote here from you that from 2013 that, quote, monetary penalties speak very loudly and in any language potential defendant understands. Enforcement needs to be aggressive in our use of penalties. And I'm curious, do penalties against corporations actually deter actions and conduct that violates the rules, do you believe? Or why are they easier to levy these against companies versus, individuals? I mean, and is there some sort of level where the SEC isn't going to go after an individual or an employee at a certain level where public securities there's been fraud within these public companies?
There's no question that cases against individuals are the greatest deterrent. I think individuals who feel like they're at risk will be deterred in their conduct. I think that's the case. And actually 70% of our cases last year were brought against individuals, involved individuals being charged. Having said that, I do think that there is an important place for monetary remedies against corporations. I think those kind of penalties have great impact. I think they encourage the increase in compliance. They encourage increased focus on compliance. They encourage shareholders and directors to pay attention and to ensure that executives are focused on making sure that there is compliance. So for all of those reasons, I think corporate penalties are important, but individual cases are critical.
Is there a written policy as to what determines that for the recommendations?
A written policy for corporate penalties?
No, is there a written policy that staff follows as they are trying to determine corporate versus individual?
There are internal guidelines about generally how to look at penalties, but I don't know.
Are those? I mean, there's always internal guidelines. We have internal guidelines in my family, but that doesn't mean they're necessarily written down. I mean, how, are they written? Are they policy when someone comes in and is new to this? Is there something to review?
I believe we have internal guidelines, but they generally set forth factors to consider in each case. So in other words,
do you do or don't know whether they're written down?
Well, I mean, for example, there's a 2006 release that the Commission put out on corporate penalties that contains 9 factors that are relevant to corporate penalties. And in every case, we consider how those factors impact the case. And in a particular case, we may look at a couple or 2 or 3 of those as being more important than the others. But yes, that's one example.
Okay. Would you be willing to provide this committee with those written?
Sure. The 2006 statement I'm happy to provide to the committee. Sure.
Okay. And that's the extent of any of the guidelines that you deal with and staff would deal with?
I believe we do have some internal factors to be considered. I'd have to go back and look at our internal guidelines. But the public realm, there's also, I should note, cases out there, case law that articulates particular factors that should be considered in looking at penalties, and we obviously follow those as well.
Well, my time's expiring, but I think what I'd like to do is follow up in written form with you and see what we can pull together. So, thank you, Mr. Chairman, and with that, I yield back.
Thank you. Go ahead. Thank you. The chair now recognizes the gentleman from Delaware, Mr. Carney, for a period of 5 minutes.
Thank you very much, Mr. Chairman. Thank you for coming in today. Just a couple of quick questions. One is, and it's been referred to a little bit before, you know, we as members hear from our constituents all the time about the fact that so few people were prosecuted or went to jail, is what I hear specifically from constituents as a result of the financial crisis. How would you respond to that?
I would say, obviously, I can't speak to the criminal authorities, right, because we don't have criminal authority at the SEC, and so I can't speak for the Department of Justice, which does. I will say that our record in the financial crisis, I think, was very strong. We brought 170 cases against 175 entities and individuals, including 70 CEOs, CFOs, and senior executives. We got tremendous amounts of relief and disgorgement and penalties as a result of the financial crisis cases. And so I think when you look at our efforts during the financial crisis, it was extremely strong. You know, one example, just to point to, is the Bank Atlantic case, which we tried in Miami a couple of months ago, and we got a verdict against the CEO and the firm for misrepresentations relating to loans arising out of the financial crisis. Just an example of a case that we brought that was very strong and important.
Could you characterize some of the other cases? I mean, what generally were you, or is it just a broad range of things?
Well, it was a broad range of things. I mean, I think it included cases like a case against Citi's CFO relating to the disclosure of their subprime exposure, case against Countrywide Financial relating to issues relating to their mortgages, as I mentioned, cases against Thornburg Mortgage relating to representations they made to investors. Bank Atlantic was misrepresentations by a CEO regarding the performance of loans on the books of the bank. Some examples.
Just shifting gears considerably, actually. Just interested maybe on your reflections here. A number of us have heard presentations about the possibility of a venture type exchange, and I've talked to folks in the business, and some of the concerns they raise are around fraud and that kind of thing. And the example in Canada, there actually has been some fraud. What concerns would you have with respect to a venture exchange, if you will, from an enforcement, from a fraud perspective? And if you're familiar with that at all, I'd be interested in your viewpoint on that.
Well, obviously, the question about venture exchanges is one for the policy divisions, for the Division of Corporation Finance, Division of Trading and Markets.
But my question more is, what should we be concerned about?
Sure. You know, I think I wouldn't characterize it as anything different than we're often concerned about, which is investor protection and whether investors are being misled. You obviously want to make sure that any representations a company that lists on a venture exchange are accurate. And so we would obviously monitor that, just like we're monitoring all kinds of other things, like, for example, Rule 506, Jobs Act, other types of initiatives that relate to raising money from investors. We look for fraud and all. So I don't know whether venture exchanges would present a larger,
Yeah, I think that's really the question. And
I don't know enough about
it
to have a view on that, yeah.
Well, thanks very much. Thanks for being with you. I yield back.
Okay.
Gentleman yields back. The chair now recognizes the gentleman from Texas, Mr. Nagelbauer, for a period of 5 minutes.
Yeah, thank you, Mr. Chairman, and thank you, Mr. Rest. Thank you for coming today. You know, under Sarbanes-Oxley, the Commission is authorized to take pools of cash collected from defendants in the SEC enforcement actions and distribute the money to injured investors. I think they call those fair funds. The penalties are deposited into the fair fund, which functions like a private class action settlement. In an op-ed in November of 2014, the Wall Street Journal, SEC Commissioners Gallagher and Peower expressed concerns that about the use of those funds, and they believe that class action lawyers have an incentive to round up potential victims in the SEC insider trading cases and arrange a substantial contingency fee, then lead fair fund campaign under the guise of grassroots movement by harmed investors. I think in the particular case that the Commissioners Gallagher and Peel were referring to was the SEC versus CR intrinsic investors. Is it in and I think in that case there were thoughts that it was difficult to really tell who the injured parties were in that case, and that a substantial amount of money was involved in that transaction. And so I guess were you aware that before the vote that the Commissioner's office received dozens of suspiciously similar letters from purported victims urging the Commission to petition for a fair fund?
So the CR intrinsic case did involve proceeds from a settlement that involved insider trading. Our assessment based on the law and Congress's prior activity in this area is that contemporaneous traders, that is traders that traded at the same time as the insider trading occurred, were victims under the law as it's been defined by both the case law and by Congress in the past. And so our recommendation to the court was that a fair fund be established both from the disgorgement and from the penalty amounts in that case, and distributed appropriately. And we also reminded the court that the statute does not allow for the use of attorney's fees, the use of the funds to pay attorney's fees as part of that distribution. And so our perspective was that a fund should be created, an administrator should be appointed to determine who were the victims and then distribute the money, but that it shouldn't go to attorney's fees.
Well, I mean, you may not directly pay attorney's fees, but if a bunch of trial lawyers get together and go out and solicit people that could have been injured in that trading or that specific case, they get a contingency fee. While the funds from the pool don't directly go to pay those attorneys, indirectly they would go to the attorneys. I guess they would be netted from the settlement with the individual that claimed their damages. Wouldn't that be correct?
I don't know what arrangements there are between investors and their attorneys, and obviously we don't look into if we award a settlement, if money is awarded out of a fair fund to a particular investor, what they then do with that money, it's not something that we can have visibility into. And so I think the only question that we were faced with was whether those contemporaneous traders were victims. And a majority of the Commission obviously approved the recommendation that we recommend to the court the creation of the fair fund.
So what is the current policy of when you establish a fair fund and when you don't establish a fair fund?
Whenever we have investors that have been harmed that we can identify, and wherever the money is sufficient such that it makes it justifiable to create a fund, we will recommend a fair fund. It obviously is a facts and circumstances determination based on the amount of money, who the victims were, what the conduct was, et cetera.
What is the current status of the intrinsic case?
I'm not 100%. I think an administrator has or will be appointed. I'm not 100% sure about exactly where. I'm happy to get back to you with the current status if I can go back and check. I believe it was in the planning stages still, where I think there had been an administrator appointed, and now they have to come up with a plan.
And how many fair funds have you set up since the authorization in Sarbanes-Oxley? Do you know?
I don't have a number of fair funds. I can tell you the amount of money we distributed through since Sarbanes-Oxley is about almost $10 billion.
But you don't know how many funds?
I can't tell you. I mean, it's hundreds. But I don't know the exact number. Yeah. I can get back to you with that if you'd like.
And when you say you distributed $10 million, that was the amount of money that went into the fund?
$10 billion.
$10 billion?
Yeah. I think that's the amount distributed. There are occasions, I think, where money goes into a fund, but there's excess and it comes back. So I'm not sure whether I think that $10 billion is actual disbursements.
Yep, I'd be interested to know what the current status of the intrinsic case is.
Okay. We can get back to you on that.
Thank you.
Gentleman yields back. The chair now recognizes Mr. Sherman for a period of 5 minutes.
Thank you. I want to focus a little bit on some of the less sophisticated, more clearly illegal, but sometimes not detected fraud that goes on out there. Best example is Madoff. I want to make sure that you have learned all the lessons that can be learned there. One of the things with Madoff is he submitted audited financial statements audited by a firm so small that they could not have done an audit of his operation. You might also have a circumstance where the firm is just barely enough to have done the work, but if they did it, That would have to be like half their fees for the year, and they would have lost independence. You may have a circumstance where the audit firm doesn't exist, and you may have a firm that does exist, but the issuer just steals a piece of stationery. What systems have you gone through to make sure that the auditor sends you a copy of the audit opinion or emails it into you, so you know that the issuer is not submitting a forged audit opinion?
Obviously the PCAOB was created by Sarbanes-Oxley to oversee the public audit of public companies, and I think that they have, mechanisms.
This is more, how do you?
Is your question in connection with?
Yeah, when a registration statement is submitted,
right,
it's submitted by the issuer. How do you, when a Reg D document is submitted, et cetera, all levels, from public to A+, to A- to A++, whatever, Reg A, Reg D, how do you make sure that, in fact, the CPA firm did, in fact, sign that opinion? It's not a forgery.
Well, the division.
Do you bother to contact the firm?
The Division of Corporation Finance reviews filings by companies.
Do they have a system, or you don't know whether they have a system?
Sitting here today, I can't tell you what their system is. I know if they were to find a red flag that suggested there's an issue, they would refer it to us.
The answer is, I believe, last I checked, they have no system. Madoff happens. Madoff happened because 10 or 12 of the barn doors were open. They've closed one or two. They've gone on to other things. There'll be more fraud, and then there'll be more work for you folks to do and more big fines to collect, which will get the agency more big and good headlines. What does your enforcement division do with regard to the Ponzi schemes that are out there being sold by people who wouldn't know a registration statement if it hit them in the face? Are you trolling the internet and finding the Ponzi schemes, or are you going to tell me that, well, you're not a law enforcement agency, so you won't do that?
We do that, amongst many other things. We obtain over 15,000 TCRs, tips, complaints, and referrals a year.
Well, I'm not talking about. I'm talking about. Are you trolling, or are you just waiting for people to tell you?
We do have proactive efforts in a number of areas, including pyramid schemes, microcap fraud, and that kind of.
Do you actually have at least one employee who's trolling the internet, finding the bogus offers that are out there to investors?
We do in a number of areas, including microcap fraud, pyramid schemes, and the like. We do affirmative, proactive surveillance.
Gotcha. Now, you're asking for a 7% increase in the SEC's acting for a 7% increase in the budget. How would that be spent? Why is it necessary?
Yeah, the portion of that budget that is related to the Enforcement Division relates to 93 positions that we've asked for. I think the way we break it down is really three categories of additional needs. One is data analytics. We anticipate 20 people would be in data analytics. We have a huge amount of data now available to us. Using that to detect misconduct is a great opportunity and something that we really need to be doing. Second is for investigators, about 50 additional people there. And there, I think the point is we have just tremendous resources that are necessary to investigate complex schemes. And the third area is trial attorneys, about 20 trial attorneys or so. And there, we've seen an increase in trials.
In these 93 positions, that would be roughly a 7% increase of your division, or is it somewhat different than that?
Our division now is about 1,300 or so employees. If
pretty close to 7%.
I guess it's about close to 7%.
Close enough for government work. I yield back.
Yeah.
Gentleman yields back. It's my understanding that votes have been called. So what I'd like to do is to have questions from Mr. What I would propose doing without objection is that we have questions from Mr. Royce and then Mr. Himes and then we recess. So with that, I recognize Mr. Royce for a period of 5 minutes.
Thank you, Chairman. Director, as you point out in your testimony, policing insider trading is central to the mission of ensuring confidence in the markets, and I assume that you often get anonymous tips, and anonymous tips on insider trading cases or have things referred to you from CorpFin, and I'm wondering what other avenues you look to for information. For example, if a federal judge raises serious questions about insider trading in a ruling, Is this something that could trigger the commencement of an investigation into securities laws violations, or is an investigation, let's say there's an ongoing investigation, are issues raised in a court proceeding potential evidence for the Division of Enforcement?
We have a number of sources of information relating to insider trading cases. A prominent source is SRO referrals. FINRA and ORSA refer cases to us often. We also now have developed internally a mechanism for finding insider trading through data that we have, blue sheet data that we have. Obviously, if a court decision were to come out which suggests there's insider trading, it clearly is also something we would look at.
If a judge raised those serious questions, I see. As for what makes up to insider trading, do you look to the law for guidance? Do you discuss potential investigations with your colleagues in Corp Fin? I assume it's not always as easy as Justice Potter Stewart's rule that you know it when you see it.
We do obviously have dialogue internally, including with the Division of Corporation Finance, about violations of the insider trading laws.
And it's clear to me that sometimes you have to answer complicated questions in order to bring an insider trading case to the Commission. Under the Securities and Exchange Act, and specifically Rule 14E3, there are many hurdles that have to be overcome, and I was hoping you could help me understand some of those today. The first is this question of what constitutes a substantial step or steps toward a tender offer. Do you look for tactics commonly associated with a hostile bid? Say, for instance, Company A is making an offer to buy Company B. If Company A begins a PR campaign and hires financial and legal advisors and sends multiple threatening letters to Company B's board of directors, directly communicates with Company B's customers and employees, would this not meet the threshold of commencing a hostile tender offer?
I think it's a facts and circumstances inquiry. What a substantial step towards a tender offer is really can be a complicated question in certain cases, obviously. So I think it really depends on the facts and circumstances.
And here's a follow-up on this. What if Company A's board meeting materials clearly reflect a recognition by the board that a move to acquire Company B would most likely require a hostile takeover? Or what if Company A simply makes a self-serving statement that it is not taking a substantial step towards a tender offer? Is this enough to establish that as fact?
Again, I think it's a facts and circumstances inquiry. I'd need to really sort of examine the facts and circumstances to have a view on that.
And another question that has only recently been raised is, what is the SEC's definition of who would be considered a co-bidder or a so-called co-offering person and therefore exempt from the scope of the rule?
Again, it depends on the facts and circumstances and what kind of conduct the individual or the entity takes.
Would a person or persons brought on as a strategist or financier by Company A qualify as a co-offering person under the rule? What would have to be established for this person to qualify for the exemption from the disclose or abstain rule that applies to those with material non-public inside information? I was hopeful that the SEC can provide some clear guidance on these issues in the future, and so that's why I asked the question for the record, if I could have a response on those.
Again, it's a facts and circumstances inquiry. I'd really need to examine the facts more closely.
Thank you, Director.
Thank you.
Gentleman's time has expired. The Chair now recognizes Mr. Himes for a period of 5 minutes.
Thank you, Mr. Chairman. Thanks for being with us. I have two questions pertaining to insider trading. Like my colleague, Mr. Lynch, I'm working on a bill that takes a slightly different approach. And my two questions are this. First, there's some ambiguity in the press reporting about the SEC's beliefs around the implications of the Second Circuit's Newman decision, Law 360. I think they quoted you as saying you've got the ability to adapt. Late January, Southern District prosecutors say they're going to drop some prosecutions, and of course we're hearing lots of talk about the possibility of convictions being overturned. So my question is, question number one is, regardless of the future of the Newman decision, do you think we would be well served, big picture, by clear statutory liability. In other words, a law prohibiting insider trading. Question number one. Question number two, I'll let you divide up the remaining time in terms of how you want to answer these. Question number two, this would be helpful in thinking through the legislation that I'm working on. How does the SEC think about the threshold between civil and criminal liability? I guess the right way to ask that is, when do you and how do you take the decision to refer a case like this to the DOJ for criminal prosecution?
First, let me just comment on the impact of Newman. I think it's fair to say it's a very significant decision, and it will impact certain of our cases. Whatever has been reported about our views, it's very significant. It also, though, as I've said before, does not mean that we don't have insider trading cases. We brought cases against 16 defendants since Newman, and we will continue to do that. We will work within the confines of Newman. We have a lower standard of proof on the civil side, where we have to show negligence by knowledge of a tippee, and so that helps. We have other circuits we can go to. So there are ways we can deal with Newman, and I think courts may well distinguish the facts on Newman as they did in the last couple of weeks in the Southern District. So that's just our views on Newman. And we filed an amicus brief. The rehearing is still pending, and so obviously whatever happens on that will impact our views. As for the views on legislation, I think that obviously is a decision for the Commission to make about what their position is on legislation, and they have not taken a position yet. What we have said, and we will continue to do, is we are happy to supply technical expertise as you and others work on bills. And I think, as Chair White said last week, and I think this remains our overriding view, strong insider trading laws are critical to the markets, and we think that's important, and we think that is critical, and so that remains our overriding goal, is making sure that insider trading laws are strong and that people have confidence in the markets. Now, as to the question about civil and criminal,
can I stop you there? Because, of course, some might argue that there are no insider trading laws, that you rely on anti-fraud provisions. So can I interpret what you just said as encouragement that perhaps we should do away with some of the ambiguity emergent from the way these cases have been prosecuted?
No, I think I'm saying it's really up to the Commission, and they haven't expressed a view on this, and I don't want to be interpreted one way or the other on this. I think 10b-5 does prohibit insider trading, as the case law has shown. It's deceptive conduct, and it's illegal under 10b-5. So that's really what I was saying. And just on the civil criminal question that you asked, obviously violations of the securities laws, the thing that makes it criminal is intentional conduct, where we can show intentional conduct beyond a reasonable doubt. That's what makes it criminal. Obviously, every violation of securities law could be criminal if it's done intentionally, and we can prove it beyond a reasonable doubt. And so in insider trading cases, what we do, we often work with criminal authorities as well. They have tools that aren't available to us, including undercover operations and the threat of jail and those kinds of things. And the question about whether something goes criminal versus civil is often a question of the evidence. Typically, you'll have a cooperator in a criminal case, or you'll have a recording, or you'll have some sort of definitive evidence that can prove it beyond a reasonable doubt. In our civil cases, we often have circumstantial evidence. You see somebody trading right before an announcement. You see them getting a call from an insider right before they trade. You see evidence of suspicious trading where they're trading 2/3 of their net worth right before an announcement. They have a relationship with somebody who's an insider. So there's lots of circumstantial type evidence that shows it, and we think that can prove it by a preponderance of the evidence, but not always is that sufficient to show beyond a reasonable doubt.
Last question. Newman hinged on the knowledge of the tippee, of the tipper's personal gain and the existence of that personal gain. Do you think that the tippee's knowledge of the possibility of personal gain on the part of tipper, do you think that that is a sort of an essential feature to liability of the tippee?
Well, that's what Newman says, and we had previously, our view was that it wasn't, but the Southern District didn't appeal that portion of the Newman case, didn't seek rehearing on that portion of the Newman case, and so I think it will stand. And so Newman, at least in the Second Circuit, governs there. As I mentioned, the way we deal with that is we have a lower standard of proof on that. We just have to show that the tippee should have known that the tipper had a personal benefit, and that gives us an ability to show, for example, that the nature of the information was such that the tippee should have realized that it came from somebody who had personal benefits. So.
Thank you, Mr. Ceresny. The gentleman's time has expired. The list that I have now is Mr. Schweikert, Mr. Poliquin, Mr. Hill, and Mr. Duffy are the ones that we'll expect to hear from or have questions when we get back. And without objection, we'll recess until 10:45. we'll gavel the meeting back to order. Thank you, Director, for your patience. And what I'd like to do is go ahead and recognize the gentleman from Wisconsin, Mr. Duffy, for a period of 5 minutes. Starting now.
Thank you, Mr. Chairman. Mr. Serezny, you are a lawyer, correct?
I am.
And you used to be a federal prosecutor, correct?
I was.
And now you've moved over to the SEC. Yes.
Yes.
Yes. Very easy questions. And you care about due process, I would imagine. Yes?
I do.
Who hires the ALJs that work at the SEC?
I'm not sure of the exact process. I'm not involved in the process.
But the SEC hires the ALJs, right?
I believe, actually,
you should know the answer to that. I mean, it's not some outside group, right?
I don't. I think that the chief judge, Judge Murray, may be well involved in it. I assume ultimately it is approved by either the chair or the commission. I'm not sure.
At the SEC. So the ALJs are hired by the SEC. They're paid by the SEC, correct? Yes.
They're paid by the government. I don't know, exactly where the money.
In the administrative law proceedings, who makes the rules in regard to those proceedings?
The commission.
The SEC does, right?
That's correct.
Right. So not some third party. You actually make the rules by which you get to litigate cases or prosecute cases, correct?
I think they're subject to notice and comment, but yes, it ultimately is.
But you make the final rule. You can say, I'll listen to you, I'll hear you, but I'm going to make the final
like
decision.
other rules. That's correct.
So with regard to discovery in the ALJ proceedings, do you have the same discovery requirements going the ALJ route as you do in federal court?
Actually, you have more extensive discovery.
More extensive?
Yes, we turn over our whole file typically within 7 days of bringing.
Are you required per your rules to turn over those documents?
Yes, we are.
So your testimony is the discovery requirements at the SEC going the administrative route is more extensive than the federal courts.
Our obligation to produce documents and items that are in our file is more extensive.
So do you have a duty to disclose exculpatory evidence to the defendant?
In an administrative proceeding, we do, not in a district court action.
So you are required to, per your guidelines, to disclose exculpatory evidence?
Per the rules of practice, yes.
Okay. And what happens if you violate that rule?
I assume there are implications for the proceeding, but I'm not familiar with instances where that has occurred. But I imagine there would be implications in the proceeding.
In regard to the admissibility of hearsay, is that admissible in federal court?
Hearsay is, unless it's subject to an exception. I mean, there's obviously a number of exceptions to hearsay.
It's not admissible, right?
Hearsay that is not subject to an exception is not admissible.
Is it admissible in your proceedings?
The rules of evidence are relaxed in an administrative proceeding, but the administrative law judge has discretion.
So the point is you don't have the same rules on hearsay at the SEC as you do in federal court.
They could, although one thing to say is the administrative law judge decides on the weight of the evidence. Obviously, if evidence is hearsay, it may
The administrative law judge that is employed by the SEC, that one?
The administrative law judge.
I wanted to talk about that. What was the? I thought I heard that correctly. What was the win rate last year in the cases you brought in the administrative in those administrative cases?
Last year.
Did I hear that it was 100%?
Last year, but not.
That's 100%.
Not in prior years, though.
But last year was 100%. You won every case. How about with regard to the cases that you brought in federal court? 100% there?
No, it wasn't.
No. Was it? You won 11 out of 18?
That's correct. 11.
Do you think there could be any correlation when you actually hire the judges and you set the rules that you win all the cases? Do you see a correlation there? And that you might say, you know what? I want to bring more cases in front of the judges that I hire and abide by the rules that I set, as opposed to letting these cases go into federal court. And lo and behold, wow, I win them all. And I believe in due process. This is a great way to administer justice when you work at the SEC.
I will just say this. We are not afraid to try cases in federal court. In fact, we've won 11 of our last 13 jury trials in federal court. We just won one yesterday. And we still bring a majority of our cases in district court. So we're not shying away from using district court.
Regarding press releases, I read a few of your press releases. I don't know if you would agree, but when I read your press releases, I read them and go, this defendant, man, the SEC says they're guilty. They lay out the case, they lay out the facts, and they conclude guilt. As a former federal prosecutor, from the U.S. Attorney's Manual, there's a requirement that says, a news release should contain a statement explaining that the charge is merely an accusation, that the defendant is presumed innocent until and unless proven guilty. And I was a former prosecutor, only a lowly state prosecutor, and we would abide by that rule as well. I read this, I'm amazed at the stuff you put in your press releases with regard to defendants. Thoughts on that?
I think our press releases always make clear that the allegations are being alleged, and they make it clear that they have not been proved and they're subject to being proved.
What do you think a federal judge would do? If you, as a federal prosecutor, put out a press release about a defendant like you do about a defendant at the SEC, do you think he would go, oh, wow, that is right in line with federal procedure?
I think it is in line.
You think it is?
Yes, I do.
I would disagree in the most strong way. I see my time is up. I would yield.
Thank you, Mr. Duffy. And the gentleman's time has expired. The chair now recognizes Mr. Poliquin for a period of 5 minutes.
Thank you, Mr. Krasny, very much for being here this morning. I appreciate it. And I want to thank you also for your good work and your staff in pursuing the bad guys in the financial services space. I know that you are doing the best you can to make sure you protect our consumers. Now, if you don't mind me beginning by reminding both of us that the reason we have such a strong economy, in great part here in America, is because we have such a diverse and creative and liquid capital market and also financial services sector. Not only do they provide the capital that we need as an economy to grow and create better lives and more jobs for our citizens, but it also provides the tax revenues we need to defend ourselves and take care of those who are truly in need. Now, we both know that this country is a country of laws, and it's very, very important that whoever comes before you, and I'm sure you'd agree with this, Mr. Director, that they have a fair hearing. This is embedded in our Constitution, the Fourth and Fifth Amendments, and I'm sure you want to make sure that anybody who's brought before you folks have an opportunity to defend themselves in a fair and predictable way. Whether or not you're in front of a traffic court in Bangor, Maine, or someone here in Washington that's in the financial services sector before you folks. Now, one of the concerns that I have, to be very candid with you, has been discussed a little bit this morning, Mr. Krasny, is that during the past few years you seem to have relied much more on an in-house administrative process to chase down those you think are or have been accused of violating our securities laws. Now, if I'm not mistaken, this internal in-house procedure, they are located and they take place at your offices. Is that correct, in-house?
In D.C., we have a hearing room in the SEC.
Okay, so it's essentially at your building.
In the regions, actually, often the hearings are not held in our offices. Often they're held in federal courts or other places.
Okay, but I'm just talking about your administrative process. And if I'm also not mistaken, Mr. Krasny, is that you folks actually select the administrative law judges that oversee these proceedings. Is that correct?
As I mentioned, I'm not 100% sure of the process by which the ALJs get hired. I know that the
okay, but you folks pay them. Do you folks pay them?
I mean, they're paid by the government.
Okay, they're paid by the government, paid by the SEC in this case, part of your budget.
I assume that's right, but I don't know where
okay, I would make the case, if I may, sir, that if you're not in federal court to pursue these alleged violations of the securities law and they're held effectively on government property, your government property or thereabouts, and you folks are involved in some way of hiring and paying for these judges, that I would make an argument with you or make the point that they might not be completely impartial, and I want to just bring that to your attention. I'm also, if it is my understanding, that there's no jury involved, correct?
There is no jury.
Okay, and also hearsay is admissible as evidence in these proceedings. Is that correct?
As I said before, hearsay evidence can be admissible. It's at the discretion of the ALJ and the amount of weight they.
Okay, and the DLJ and these folks are the people that you hire, and for these proceedings. And if someone comes before you and they come out on the other side of the fence and they want to appeal it, they appeal it before you people, right?
They appeal it to the commission.
Okay, so
presidential appointees.
They appeal it to your organization, not an independent outside entity, correct?
Well, they ultimately can appeal to a court.
Okay, but the first appeal is to you folks, right?
First appeal is to the commission.
Here's where I'm going with this, Mr. Kresny. Everybody wants to make sure that our investors and our consumers are protected, but we also want to make sure that the folks that you bring before you also have a fair and honest process. I mean, that's part of our Constitution. Now, I would also, if I may, remind you that the financial services industry employs about 6 million people in this country in various functions, and they're good-paying jobs, and they provide opportunities for their families. And what I'm concerned about is that if you have a process that is perceived to be unfair or unpredictable, where it's stacked against the person that you bring before you or the company you bring before you, that this will have a negative impact on this part of our economy, which it provides so much vibrancy and so much depth to our economy and so much employment that this could actually hurt the folks who you're trying to help. Let me give you an example. If you're talking about a paper maker in Rumford, Maine, that I represent, or a teacher from Bangor, or a nurse from Lewiston, Maine, and they're preparing and saving for their retirement or to put their kids through college with savings, and they're dependent upon a mutual fund company or investment management firm that helps them grow that retirement nest egg or that nest egg to put their kids through college. And all of a sudden, the firms in this space are dragged before the SEC, and there's not a fair opportunity to be heard, then that will have a negative impact and raise the costs, raise the fees, and reduce the performance of that nest egg that's trying to be accumulated by those retirees. So I know there's all kinds of room to make improvement. And I would just encourage you, Mr. Kresny, as you go through this process, is make sure you're looking out for these middle-class families who are trying to prepare for their retirement by being fair to the people that are brought before you. And I bet there are ways you can make adjustments to make that happen.
Thank you, Mr. Poliquin. Gentleman's time has expired. The Chair now recognizes Mr. Messer for a period of 5 minutes.
Thank you, Mr. Chair, and thanks to the Director for being here today. I appreciate your willingness to withstand testimony. I mean, we all support the vigorous enforcement of federal securities laws and believe that it's important that you go after bad actors. When, though, those bad actors are penalized, at times the payment for that falls upon innocent shareholders who, of course, weren't a direct part of the bad activities that may have been prosecuted. Could you talk a little bit about what, if anything, the SEC does to ensure or try to mitigate the impact on innocent shareholders of enforcement efforts?
Well, we have a number of factors that we consider when we think about corporate penalties, and I think you're focused on issuers that are not regulated. I think that's the area that I think folks have focused on when it comes to shareholders and the like. And there are a bunch of factors that we consider. We consider the conduct. We consider, whether there was intent or not. We consider cooperation or remediation. We also consider whether there was a corporate benefit, that is, whether the shareholders got some benefit from the conduct. That's obviously an important factor. And then also what the impact on the shareholders is. We consider all of those things. And in every case, we decide on the appropriate penalty that would be important and useful for punishment and deterrence. And that's really our goal, is making sure that we are punishing and deterring. So in every case, we weigh those factors and reach that conclusion.
So you have agency guidelines, as I understand it, that say that you can consider the impact on shareholders?
Well, there was a 2006 release that outlined a number of factors that should be considered. One of those factors was impact on shareholders. So it is one of the factors that is looked at in connection with a corporate penalty, but it's only one of the 9 factors.
And make sure when you say release, those release are a set of guidelines of how you will analyze things. They're not requirements.
They're not requirements. They were never binding on the Commission.
Okay. So there is no assurance that each and every time the impact on innocent shareholders is required to be analyzed as part of the penalty.
Well, I will tell you that when it comes to making recommendations, we in the action memo will typically discuss all 9 factors and how they impact a particular case. So one of the factors we will discuss is impact on shareholders and inform the Commission of that. But there may be other factors that we will consider more compelling or important in a particular case that compel a penalty.
Yeah. I just would make the case that, well, certainly it's important that we have strong enforcement. Bad actors ought to be penalized, but often innocent shareholders get caught up in the mix of this at no fault of their own. And we certainly, as a committee, are looking at a requirement that the SEC must consider the impact on innocent shareholders as part of your analysis. Do you have any thought on implementing that requirement?
As I say, in almost every case, we consider it. It's one of the factors we look at, and then we weigh that against the other factors.
Okay. Thank you very much.
Thank you.
Gentleman yields back. And what I would like to do without objection maybe is to start a second round of questions. And I know there are a couple of members that are on their way back, so hopefully that'll give them time to get back here. And I think the ranking member also has some questions, but I'd like to recognize myself for 5 minutes. I guess I think a common theme that we've heard here today certainly focuses on our system of justice and the rule of law and making sure that there's fairness in these processes. One of the things I think that has been said is that the administrative procedure is not as time-consuming as the federal court system, and I understand that, and perhaps it's there are efficiencies going through the administrative process, but I think that we should never, ever, ever take a shortcut for time's sake in pursuit of something that's not square with justice and fairness, and so I know you agree with that, but there are some questions that have been raised that I think are worth exploring. One of my first questions is, what was the reason, if you know, that the non-registered registrants were excluded from the administrative process from the beginning? Because obviously Dodd-Frank included non-registrants, and there must have been a reason for that, and was wondering if you could speak to that.
I'm not familiar with the history. I think so I don't know the history there. I just know that since for a very long time, administrative proceedings have been available. Penalty authority was only given to us about 25 years ago. And so when penalty authority was provided, registered entities we could obtain penalties against registered entities in administrative proceedings. I don't know the history but
it probably had something to do with the fact that registrants are submitting themselves voluntarily to the SEC and its processes, and non-registrants are not. They're just regular citizens, whether they're bad actors or not.
I think that was probably part of it, yes. Okay. I imagine that there could have been other issues, but yes, I imagine that was part of it.
Now, with respect to the due process issues that have been raised, so there are hearsay can be allowed in an administrative process. There is no jury trial. Those are two fundamental constitutional rights that are afforded defendants in criminal trials, correct?
That's right, although I should note that the Supreme Court had ruled in Atlas Roofing, which is a case from some years ago, that that there's no Seventh Amendment right to a jury trial in connection with administrative.
Right, but we are concerned with fairness and due process, and regardless of whether it's strictly required by the Constitution or not, correct?
Undoubtedly, I'm concerned with fairness, and my view is that administrative proceedings do provide that fairness.
Okay, and so when you look at the appeals process, so the way it would work is if a ruling is made within the administrative process, and then it gets appealed to the SEC, to the Commission itself, and then it bypasses any district proceedings and goes to the Court of Appeals. So that's not a trial court. And they're not reviewing anything de novo. They're reviewing it. It's not de novo, is it?
The Commission review is de novo. The Court of Appeals review is not de novo.
And so what are the standards of review as it relates to this Commission's action? Do they give deference to the SEC in interpreting its own enforcement actions?
There is some deference given to the SEC with regard to findings of fact. I think when it comes to legal matters, Obviously, the Court of Appeals reviews that, and legal matters are subject to the Court of Appeals views. But there could be deference there as well, based upon Chevron deference. So there is a fair amount of deference that does exist for the Commission's rulings.
Now, as a part of the penalties that are assessed, there's something called undertakings that are sometimes part of the order in the administration process.
Sometimes
administrative process.
Sometimes in settlements, we will agree to certain undertakings that the defendant has to undertake. Yes.
Is there a concern, because there has been a concern expressed, do you have concern that those undertakings amount to rulemaking outside of the Administrative Process Act?
I do not.
And why is that?
Because I think in every case the undertakings are tied to the actual conduct that's involved in the case and designed typically to ensure the conduct does not recur.
But do you think that there is a danger that other participants in the marketplace look at these undertakings and then that creates uncertainty, and also, of course, avoids the Administrative Process Act, which allows for public comment and public notice?
I don't think so. We're pretty sensitive to not doing rulemaking by enforcement, and those undertakings are only obligations of the particular party to the enforcement action.
Sure, but
and they are typically closely tied to the conduct.
Okay. All right. My time has expired. Thank you, Director, and I recognize the ranking member, gentlelady from New York, for a period of 5 minutes.
Thank you. You noted in your testimony that the SEC's fiscal year budget for 2016 requests money for 93 additional enforcement staff positions. And can you describe the impact of having these additional people, and what would you do with 93 additional people in enforcement?
So there are 3 areas that we would deploy people to. First, data analytics. I think about 20 people for identifying misconduct. There is tremendous amounts of data now available to us, and developing tools that allow us to use that data to detect misconduct is critical. So that's one area. The second area is investigative activities. I think approximately 50 employees would go in this area. And here I think I would point to the increase in resources that we need to devote to investigate complicated, large-scale issues like financial reporting, like market structure, like asset management issues, and the like. These schemes have become much more sophisticated. There's these tremendous amounts of email data and other data that's required to be reviewed. And so having additional people, as well as experts in the area, would be important. And the third area is trial attorneys, approximately 20 people for trials. We have seen an uptick in the number of trials that we have. Could be many reasons for that, but we think that will continue. Probably not as many as last year. I think last year was probably more than we'll have this year, but we'll still see an increase from historical levels. And the trials do take lots of resources, particularly district court actions.
Are you active in cybersecurity in any way? This is something that I'd say everyone in Congress is deeply concerned about. The private sector is deeply concerned about it, and it's a threat, really, to our national security and our economic security. What are you doing in cybersecurity?
We're very active in the cyber area. A number of ways in which that impacts SEC enforcement. Obviously, there's lots of aspects of cyber that we don't have involvement in, but there are many that we do, including whether companies are disclosing cyber attacks promptly and appropriately, whether information is being stolen through hacking and used for insider trading or other misconduct, also whether registrants are developing policies and procedures that are necessary to guard against the misuse of information. So we have regulations like Reg SP that's out there where dealers have to develop policies and procedures to safeguard customer information. And we brought 5 cases under that regulation. And so we're very active. There are other regulations that also could apply, like Reg SCI when it comes, it's now online, but when it becomes effective, and when companies have to comply, when investment advisors have to, when broker-dealers have to comply with it, as well as the market access rule and some other rules that do provide requirements for policies and procedures. So we're very focused on this area. It's something that we obviously are devoting resources to.
Well, I believe that there would be bipartisan support for increased personnel in cybersecurity, and I think that would be an area that we really need to focus on. We know it, and we need to work in that area. I want to thank you for your testimony today. Thank you so much.
Gentlelady yields back. The Chair now recognizes Mr. Hultgren for a period of 5 minutes.
Thank you, Mr. Chairman. Thank you so much. Appreciate you being here. I'd like to bring up the issue of well-known seasoned issuer waivers, which I believe should not be in consideration for an additional penalty outside of the SEC's formal enforcement process. My understanding that there was already a thorough review process in place to determine whether a waiver is appropriate, and that this process was recently reviewed and tightened in April of this year. Wonder if you could walk us through the WKSI waiver, the WIXI waiver review process, and the steps the SEC has recently taken to make this process even more thorough.
Sure. Well, the Enforcement Division generally, it doesn't make waiver recommendations or decisions, and so we don't make those kinds of recommendations or decisions. That typically is handled by other divisions, including in the case of WIXI, the Division of Corporation Finance. Having said that, my understanding is that the Division of Corporation Finance follows the guidance that they've issued, and as you mentioned, they did update that guidance in April of this past year in determining whether a WIXI waiver should be provided. I understand it's a facts and circumstances determination based on the applicable legal standards, which include whether there is good cause to issue such a waiver. Ultimately, I think it's important to recognize that the waivers, disqualifications, are not enforcement remedies. We have significant remedies for enforcement violations, including disgorgement penalties, bars, et cetera. But the WIXI determination is really a determination about whether, going forward, the entity can be trusted to comply with its obligations under WIXI.
Let me get into that a little bit more. Registration requirements for a new stock offering I know can be burdensome for a public company. The added red tape leads to delayed offering oftentimes, which can run up against changing market conditions, which certainly can adversely impact the issuer. WIXI is able to file an automatic shelf registration statement on Form S3 when preparing a stock offering. What does the accelerated process mean for those companies looking to raise capital?
I would have to defer to the Division of Corporation Finance on the impact of that. That's really a policy question, which is not really one that I'm involved in.
Okay, let me move on then. SEC maintains the authority to deem a WIXI an ineligible issuer and revoke its WIXI status for 3 years if the Commission views the company as having disclosure practices that would be less reliable than the disclosure of other issues and thus unsuitable for short-form registration or ineligible for disclosure-related relief. This authority, paired with the annual and quarterly filings, to me seems sufficient to address any issuers that may potentially abuse their WIXI status. Do you agree with that?
Again, in the Enforcement Division, I think that would be a question really for the Division of Corporation Finance, which is the policy division involved in determining WIXI waivers.
Yeah, I've got one more question. Let's see if you're able to answer this. On the issue of well-known seasoned issuer waivers or WIXI waivers, my understanding is that there was already a thorough review process in place to determine whether a waiver is appropriate, and that any further thing, let me just understand a little bit more about your role with WIXI and any suggestions you have there. I know it came up earlier in the hearing. I wasn't here, but wonder if you could maybe just talk a little bit again about your role and suggestions we have, concerns certainly that we're hearing of maybe overstepping or additional problems that are being handed out. So wonder if there's any other further involvement that you have or your department has.
Well, we investigate the misconduct, so we know better than anyone, I think, at the Commission what the nature of the misconduct was, who was involved, what was the duration, et cetera. So we provide all that information to the Division of Corporation Finance or Investment Management and provide our views on that. They then go and apply the applicable legal standards to determine whether a waiver is appropriate. And my understanding is that it is a rigorous process where they review the facts and circumstances closely to determine whether the applicable legal standards are met.
Well, I would agree with you. My understanding is it is a rigorous process. The thorough review process is already in place, and with it being recently reviewed, have some concerns of additional action being taken there. I appreciate it. We'll follow up with other authorities as well, just to get some more clarity for ourselves and see if there's anything else we need to do. With that, Chairman, I yield back.
Gentleman yields back, and the Chair now recognizes gentleman from Arizona, Mr. Schweigert, for a period of 5 minutes.
Thank you, Mr. Chairman. And Chairman Hurt, that seat sort of, you look good there.
Thank you.
We'll explain the joke later. Forgive me, but a lot of the obvious questions have already been asked. So could you help walk me through just a couple things and, the education of David? One of my great frustrations is 3+ years ago, this body, actually even this committee did things like the Jobs Act. And over there's Reg A and crowdfunding. And apparently in the rulemaking side of the ledger, those things are backed up. Will they ever reach out to you and your division and say, we're doing a rule set. Tell us how to keep the consumers safe. Do you ever have input and dialogue in the crafting and design of those rule sets?
Obviously, rulemakings are handled primarily by the policy division, and we are not directly, they obviously handle, but in cases in which there is an enforcement angle on which we can be helpful, we obviously do provide. They do consult with us. They do ask us our views, and we provide input as requested to the rulemaking policy division.
Look, that doesn't bother me. In some ways, it seems absolutely appropriate, whether it's been in writing or a water cooler conversation. For some of the new technologies, whether it be crowdfunding or some of the new uses where we see people using 506 and sort of regional basis of those, from your sort of enforcement side and observations, has access to information, very open disclosures, in sometimes a readable fashion, is that an interest? Have you seen it done? Have you seen benefits from that?
Again, I don't know that I'm in a position to really judge the impact that has on capital formation, on the raising of capital, because I think that is a question for others. I'm really focused more on the issue of, is there fraud? Is there misconduct in connection with the offerings? And when there is, obviously, we're very involved.
When you design, because you'll be part to designing a consent decree or an agreement.
A settlement agreement, yes.
Forgive me. All right, settlement agreement.
Yeah, an order. Yeah.
In that settlement agreement, have you ever done part of the mechanics for fixing the bad acts or the agreed upon bad acts? The way the bad actors tell their story or disclose risk or put out information so for the investor, the consumer of the product, they're doing better decision making.
What we sometimes will do, if there's a case involving failure of disclosures, for example, an investment advisor that has failed in their disclosures and misled investors, we sometimes will, as part of the undertakings, require them to craft policies and procedures aimed at ensuring that their representations to investors are accurate. So yes, what we often do is we will design undertakings designed to try to get at the misconduct, and if the misconduct involves material misrepresentations in marketing materials, we very well may include a requirement that they have a consultant come in and provide advice on policies and procedures going forward.
Is this some of your staff behind you?
Yes, some of
I can almost tell generationally, because I don't see any gray hair. I've realized Washington is run by a bunch.
I've gotten more since I've been here.
Yeah, 30-year-old brilliant savants. For many of the folks, young folks we work with who are entering into the investment world, they want to see it online. They want to see a blog discussion about the investment. They want to see sort of open dialogue where people are on each side of the good idea, bad idea. You may actually have a very unique window as part of your settlement operations to sort of reach out into that world and say, maybe it's time to enter this century of disclosure instead of giving me another half-inch thick binder with microtype that with my aging eyes I have trouble reading. So just one sort of one-off suggestion as we start to move into this generation, this century of regulation. Last thing, and this is a little bit more narrative of a question. How many enforcement actions were there last calendar year?
755. Last fiscal year was 755. We don't track it by calendar.
Well, any sense what the sort of average settlement cost was?
Well, it was, $4.16 billion was ordered. Some cases.
More of a mean.
Yeah,
You probably had some very large ones.
It's very hard to say because some cases obviously have large monetary remedies, others have none. So it really varies.
For almost every member, right and left, we've had that person that comes into our office and says, I'm subject to an action. I don't think I broke the rule. My lawyers are telling me it's cheaper just to agree and write a check. I may send you a sort of a little narrative question in writing, saying, and I know that may be hard to quantify, but I'm sort of curious how many of the settlements are actually, I admit I screwed up, or I admit it's cheaper to write you a check and admit than it is to defend myself.
Well, I can't comment on what the reasoning of somebody in settling with us is. I can only say that when we charge someone with misconduct, we believe that there is a violation of law, and we believe that based upon our understanding of the law and the facts.
Thank you.
And thank you, Mr. Chairman.
Thank you. The gentleman's time has expired. The chair now recognizes on the second round of questioning, recognizes Mr. Poliquin for 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Krasny. Again, I appreciate it for you being here, and we want to pursue, I'd like to pursue a little bit more what we were discussing a little bit ago. And again, I want to make sure that I salute you for your goal and your hard work and that of your staff for pursuing the bad apples in this particular industry. But I do want to continue to ask a few more questions about your in-house administrative procedure. Last year, I think it was said just a moment ago that you had a very high success rate with respect to your in-house administrative procedures as far as finding I'm not sure, I'm not an attorney, a conviction rate is concerned, about 100%.
Liability, and yes, although, as I said, yesterday we just lost one.
You poor thing, yeah. But I'm talking about I'm talking about last year. So you were completely successful.
Yes, and now, that was unusual.
Yeah, okay. Well, if I'm not mistaken, last year also, when you went to federal court to pursue some of these bad apples that turned out not to be bad apples, you had about a 60% success rate. Is that right, roughly?
Can I just
quickly, because my time's expired.
It was a little over 60%.
Okay, but there's a big difference.
I would say most of the losses were in insider trading.
Okay, but when you have an in-house procedure, if I may so ask you, Mr. Krasny, where you select the administrative law judges, you pay them, they're held on property and your home court, and you can admit most hearsay evidence and so forth and so on. I would argue with you that you've got to be really, really careful to make sure this is a fair process. Now, it seems to me that this process might be a little bit more art than science. And let me go down that just a little bit, if I may. Do you have a written in-house set of benchmarks or procedures whereby you determine if you're going to pursue this case internally or you're going to let it play itself out in federal courts? You have a written set of procedures on that.
We have factors that people should consider, but we don't have a written set of procedures.
Okay, so you don't. Well, I might recommend that you think about doing that. I don't want to tell you how to do your job, but that would make me feel much more comfortable. Along that same line, sir, do you have a written set of procedures that allows you to determine which administrative law judges you're going to select for this particular case?
We don't select the administrative law
Okay, and
judges.
do you have written procedures on how to determine what fines or penalties will be imposed on those you found to be in violation of law?
As I said, there are factors.
Okay, so there's really more of an art than a science.
It is, yes.
Okay, you know what would be really helpful to me? If you could get those guidelines, if you will, to my office or our office. My LD is right back here. We'll be in touch with your office. I'd like to see your written documentation on what the SEC follows to make sure we have a set of fairness when it comes to how you go through to determine who's going to be internally in front of your people and who the judges are going to be and what fines will be imposed. That would be really helpful. And if you don't have those, and I think you just said you do not, then we may come back to you with a few suggestions. But that would be very helpful. Sir, may I ask you also, Mr. Krasny, have you ever worked in the investment management industry?
I have not. No.
You have not. Have any of your senior people that are involved with enforcement of the financial services industry that are around you, have they ever worked in the investment management business?
Yes, we have industry experts that have worked.
Good. Industry experts. I don't mean academics. I mean folks who have actually worked in the industry. Okay,
yes,
good. But you have not.
I have not. No,
okay.
I've represented people from the industry, but I'm
great. Well, we just had a new investment company moved to our district with 200 new jobs in Lewiston, Maine. And we are thrilled to death to have these folks there. They're new jobs, they're good-paying jobs with benefits. And I would submit to you, as you consider these enforcement actions at the SEC, that you consider that the most important thing a mutual fund company or a pension investment firm has is their reputation and their good word, their good name. It is so important to make sure that investors and folks saving for their retirement or saving for their college education have trust in that firm. And part of that is making sure that if there is an allegation that they violated the law, there is a fair process. And that's why I was asking just a moment ago, and I know your office will get back to us with some paperwork on this, to make sure there's confidence in what you're doing. And I'll tell you the reason why, Mr. Kresny, why I'm concerned. Because if you look at the EPA, or you look at the Internal Revenue Service, there's been a pattern during the last few years of overreach by these government agencies that causes American families to lose confidence in our government, that they're being treated fairly. I know you don't want to go there, and I'm not saying that you are there, but what I am saying, it would be terrific if you would think about people's reputation, their firm's reputation, and the confidence that people need to invest to save for their retirement and their college their kids' college education. And that comes with, I think, due process, or as close to due process as you can, given the guidelines that you have. Fourth and Fifth Amendment, all the things we've talked about. I'd really appreciate it if you would consider that as you go forward, and also make sure you get that paperwork to us in our office. I'd be very grateful. Thank you, sir.
Thank you, Mr. Pollack. When the gentleman's time has expired, I want to thank you, Director, for being with us today and being generous with your time. Chair notes that some members may have additional questions for this witness, which they may wish to submit in writing. Without objection, the hearing record will remain open for 5 legislative days for members to submit written questions to the witness and to place his responses in the record. Also, without objection, members will have 5 legislative days to submit extraneous materials to the chair for inclusion in the record. Without objection, this hearing is now adjourned.
Okay.
Thank you.